Well, my learned brothers and sisters, this is Advocate P. Devmorari talking to you from Ahmedabad city, Gujarat state, India, that is Bharat. In the last video, I discussed about cross-case concept, and that was part one. Main case and a counter case is known as cross case. What we have discussed last time, I'll discuss now in a very short manner, in a concise manner. In the case of complaint and a counter complaint, it is to be registered separately, but the same investigation officer should conduct the investigation in respect of the complaint and counter complaint. Why? In such a situation, legal obligation is cast upon the investigation officer to make an endeavor to find out the truth and to cull out the truth from falsehood. And the case is charge sheeted by the police officer to be prosecuted by the public prosecutor. If there are two versions regarding the same incident, one must be necessarily false, and the prosecutor will be forced to plead on behalf of the state that both inconsistent versions are true. Well, this is the position is incongruous. Now, let us discuss further. Part 2. Part 2 video starts now. Last time I had quoted was citation of Kerala High Court. It was a full bench judgment. Why only one charge sheet should be filed in two registered complaints of cross case filed by the rival groups? What are the reasons? Now I'll read out from this citation of Kerala High Court. In the light of the discussion, we heard that if in respect of a transaction relating to an offense, a case and a counter case happens to be registered by the police based on conflicting versions given by rival persons, it is not incumbent on the part of the investigation officer to file separate charges in both the cases. The investigation officer is expected to file a charge sheet only in the case where it appears to him as a result of investigation that an offense has been committed. Previously, there was CRP section 169. Now it is BNSS 2023, section 188. That is Bharatiya Nagarik Suraksha Samiti. If investigation officer finds that evidence is deficient against the accused, then he will not send the accused to the learned court for trial. That is, his power is given to him by the court, by the law. Then another section, CRPC 170, now it is 190 in this BNSS. It authorizes the investigation officer or officer in charge of the police station, if evidence is sufficient, then accused should be forwarded to learned court to face the trial. So it means he has to send only one charge sheet. There is one more reason that I'll discuss. That is convincing reason, clear reason, cogent reason. I'll discuss in the end of the video. Now, once charge sheet goes to the court, charge is framed, then the role of public prosecutor starts. What is his role? Now, in two charge sheets, if police officer sends two charge sheets, then what is his position? How is the public prosecutor to conduct himself in such circumstances? Next, why one and same learned public prosecutor should not conduct the trial in both the cases? And the third one, can learned court appoint two separate public prosecutors to conduct the trial in such a cross case? My answer is big no. No, sir. Public prosecutor under any circumstances cannot conduct the trial of both the cases charge sheeted by the police. The public prosecutor holds a very honorable and responsible post. In this country, every prosecution in a court must be conducted by a public prosecutor as a representative of the state. And those who represent the state betray their trust if they prosecute a case which they have not reason to believe to be true. The object of the investigation by the police is not to collect evidence to make out a case, but to save true cases from false. Whichever method public prosecutor adopts, it is likely that proceedings will be reduced to a disgraceful and wicked farce. The public prosecutor will be required to run with the hare and hunt with the hounds to appear alternatively in the same proceedings for the prosecution and for the defense, and to be counsels in both the cases to ride two horses at once in a scandalous competition. If these were the duties of the public prosecutor, no honorable member of the profession would demean himself by accepting the office, nor could these difficulties really be escaped by appointing two public prosecutors for the occasion. One to conduct the prosecution of each man would it be less scandalous that two counsels should appear for the crown in the same proceedings, each making out that other's case was false? If there are two cases, two charges, one public if magistrate appoints two public prosecutors to conduct the trial, then one probably say my case is strong, my case is right, and accused should be punished. He should be convicted. Other officers will talk the same thing. My case is right, accused should be punished. What is the reason? Now, double role of the accused. Double role means as an accused as well as a witness. In one case, he is accused, in other case, he is a witness. So that in that way, it is double role for him. And so far as an accused is concerned, if the police charge both versions or the same transaction under two cross cases, then this would be a case of compelling an accused to criminal himself, which is forbidden not only under the provisions of Indian Evidence Act, now it is Bharatiya Saksha Adhiniyam 2023, but also by the fundamental rights assured by the Constitution. So this cannot be done. Now, and what of the accused persons who are in turn in the dock? The public prosecutor is their champion today and their opponents tomorrow. In one case, he is witness. In other case, he is accused. The public prosecutor is their champion today and their opponents tomorrow. How can they be open with him when he is on other side without exposing to him the weak points in their armor through which he can wound them when he turn attacks them? And when all the evidence in the first case has been given, the accused in that case are entitled to know what they have nothing more to meet. But how can they prevent new evidence being elicited in the second case to fill up gaps in the case against them? Worse still, if they are made as they must often be made, witnesses for the prosecution in the second case, they will be exposed to cross-examination. In this country, no accused person can be cross-examination. Only there is remedy. If accused wants to appear as a defense witness, then when FS is being taken, FS means for the statement is being taken by the learned magistrate, he has to apply. For the statement is taken under 313 CRPC, now it is 351 BNSS. At that time, once FS is over, he has to submit an application before the learned magistrate under section 353 of BNSS. Previously it was 315 of CRPC. Now it is 353 BNSS. He has to submit an application before the land magistrate, voluntary, stating that I want to appear as a defense witness, kindly accord the sanction. Magistrate has no option but to accord sanction. Then he will appear in a witness box as a defense witness. He has to examine himself. No one will examine. In examination cannot be done by any other person. Then, learned public prosecutor will cross-examine him. And after cross-examination is over, it will be treated as evidence and it will be appreciated by the learned magistrate. Now this is over. Now the role of learned magistrate comes, learned judge comes. It is embarrassment. Citation is 1990, Supreme Court cases, Criminal 638, Nathalal and others, appellant, State of UP, and another respondent. I'll read out. It has been held by Honorable Supreme Court of India that in cross cases, each case to be decided on the basis of evidence placed on record in that particular case, without being influenced by evidence or arguments urged in cross case. Judgment to be pronounced by the same judge, one after another on the same day. Now, in this judgment, there is one clue. One cross case was on charge sheet. Police had submitted charge sheet. Second charge sheet was not submitted by the police. Then what is the remedy? Matter doesn't end there. Then other party will approach the court and make a court complaint. So in this case, there is absence of court complaint. So that court complaint will be treated as counter case. So there will be main case and counter case. Both the cases to be tried by the same judge. Judgment is to be pronounced by the learned judge, one after another on the very same day. So now I'll promise you that in the end I will tell you why two charges should not be signed. Investigation officer has to decide one important point. Who is the aggressor? There are fights between two groups. Whether there is communal right, whether it's a factional right between two groups of any caste. It can be the same caste also, it can be outer caste also. But there are fight between two groups. Then one police officer has to determine who is the aggressor, who has opened the attack, and what are the injury caused to the accused, witnesses, persons. In that sense, he has to decide aggressor and should send charge sheet in that case. Other party, I will not send him to the court because they are innocent as per him. So here also, learned magistrate, when two charges are sent, before pronouncing the judgment, after hearing the arguments of public prosecutor and defense lawyer, this is one of the important points, that is determination of aggressor. That is to be decided by the learned magistrate if there are two charges submitted by the police. Even if there is a court complaint and cross case, learned judge has to decide aggressor. He cannot take it for granted that the investigating officer is right. He has to see the evidence before the court. So this is one of the important points for not signing two charges. Now, prosecution has to explain the injuries also. But when? Prosecution has to consider also about unlawful assembly also. There are a number of points to be determined by the lawyers while arguing, by the learned judge while pronouncing judgment, before submitting the charge sheet, even IO. So this is a very important topic to be determined by the concerned person. Now, what is the obligation on the prosecution to explain injuries on accused? When obligation arises, there are two conditions. Bharatiya Nagrik Suraksha Sanhita, Section 393, subsection 1, clause B, shall contain the point or points for determination, the decision thereon, and the reasons for the decision. So, judgment is year 1979, Supreme Court 1010, Jagdish versus State of Rajasthan. It is true that, I'll read out this. It is true that where serious injuries are found on the person of the accused, as a principle of appreciation of evidence, it becomes obligatory on the prosecution to explain the injuries so as to satisfy the court as to the circumstances under which the occurrence originated. But before this obligation is placed on the prosecution, two conditions must be satisfied. One, that the injuries on the person of the accused must be very serious and severe, not superficial. If it is superficial, not to be explained. Number two, that it must be shown that these injuries must have been caused at the time of the occurrence in question. And about unlawful assembly also, there are a number of points to be determined by the concerned advocate, concerned police officer, and land magistrate. Now, part 2 is over. Hope you have enjoyed this video, got some vital information from me. I have tried at my best to give justice to this cross-case concept, which is very important. Cross-case happens all over the country, in the world also. Wherever there are human beings, there is fight between two groups, and cross-case happens. So I consider this topic is a very important one, so I prepared this video. Hope you enjoyed. Please subscribe it. Don't be miser in subscribing. Like it and share it. By this way, you can encourage me. Hope we'll meet in the next video. Thank you very much. Thank you. Thank you. Thank you. Shri Krishna Saranam.